I must be too old for this, Judge.
No problem. So we have you here, and I see Ms. Gregoire. I think we have everyone ready to proceed. And
Good morning, Judge.
Good morning, Ms. Gregoire, and welcome to the virtual oral arguments. Amazing what we could do with technology. So, Mr. Samus, right now you are the appellant in the Herald versus University Property and Casualty, and I do have actually a little timer here. So you are given 20 minutes. How much time do you wish to reserve for rebuttal?
5 minutes, please, Your Honor.
Very good. And if you're ready to proceed, we're ready to proceed, sir.
Thank you. May it please the court. My name is Scott Samus. I represent the appellants, James Harrell and Joan Rudnick. We're asking the court today to reverse an order denying a motion for, a motion for attorney's fees based on a proposal for settlement under the PFS statute 768.79. But in a larger sense, we're asking this court to fix an area of the law that needs to be fixed. And to see why, I think it's helpful to start with just a brief review of how we reached the legal landscape that we're presented with today. Of course, it starts with the MX investment case in 1997. And in that case, one party gave a PFS to the other party. The other party voluntarily dismissed the action inside the statute of limitations. And the Florida Supreme Court said under those circumstances, a fee award is not appropriate because it has to be final. It has to be a dismissal either with prejudice or a second dismissal because there's no finality to the case. And that makes sense, of course, because if you granted fees under those circumstances, there's a possibility that the case could be refiled and you would have this paradox of a fee order out there and the case gets revived and the prevailing party could owe fees. So that case makes eminent sense.
If I can interrupt you, Mr. Samus, in essence, I think you'd agree there's really no case in Florida right now basically setting forth the result that you wish to achieve. What you're asking this court for us, in essence, is to extend almost the cases of Wolford and basically MX Investments. That's in a nutshell what you're asking us to do. Is that correct?
That's absolutely true, Judge. Now, I will acknowledge that in the 2 years after MX, the third and the fourth DCA did extend it to cases where the dismissal was after the statute of limitations. But it's not clear from those opinions that the court considered the argument that we're advancing today. And it's our position that if you look at the Waller decision and you read the analysis in it, that if you combine MX with Waller, there's only one logical conclusion, and that is when you receive a PFS and you dismiss after the statute of limitations, it's the functional equivalent of a dismissal with prejudice. And, you know, I hesitate to do this, but I'd like to read, I'm sorry?
Mr. Samus, the statute itself, though, does not have any language to support what you're suggesting. Would you agree?
No, I don't agree, Your Honor. In fact,
well, there's nowhere in the statute does it say that if you dismiss without prejudice and the statute of limitations have run, it's a functional equivalent of a judgment. Is that right?
No, it doesn't say that in the statute, but it didn't say that in 627-428. And that didn't stop the Florida Supreme Court from saying that we're going to treat a confession of judgment as triggering the statute. And in fact, Judge, it's easier under the PFS statute because if you look at 627-428, it clearly requires a judgment.
Well, help me, Mr. Samus, if I tell you that I look at statutory construction as a textualist and I am wedded to the words of a statute. Give me your best argument about why I should be persuaded by your argument.
I'll read you the sentence from 768.79 paren 6. Upon motion by the offeror within 30 days after entry of a judgment or after voluntary or involuntary dismissal, the court shall determine whether fees are involved or fees are appropriate. So the word voluntary dismissal is in the statute. There is no impediment. And you know what? It doesn't say voluntary dismissal with prejudice. So in fact, as a textualist, if you interpret the words of 768.79 as they are written, it doesn't say voluntary dismissal with prejudice. It says voluntary dismissal. So therefore, The decision we're asking for today is entirely consistent with the words of the statute.
But we all know that a dismissal without the qualifier, with or without prejudice, is presumed to be with prejudice, right?
No, it isn't. The law is exactly the opposite. A voluntary dismissal that does not designate is a voluntary dismissal without prejudice.
Okay.
Okay. Now,
Mr. Samus, can we go back to the argument on the Wofford case that you're wanting us to follow the reasoning in? And in that case, what we have here is a little different than what was in the Wofford case. In the Wofford case, there was a special relationship between the parties, right? We have an insurer and we have the insured. And the statute in that case is one where fees would have to be pled from the initial pleadings, right? Whereas here with the PFS, the proposal, that's something that comes later during the lawsuit. And so I can follow the line of reasoning in Wofford that the Supreme Court was looking at was, okay, well, here you have a special relationship. The statute allows for fees. And so it is basically a confession of judgment for the reason that if an insurer is going to deny and make an insured go to court and then all of a sudden settle later and settle for payment, then we're going to consider that a confession of judgment. I'm having trouble seeing the same analysis that would be applied in this case, because while I agree with you that when someone voluntarily dismisses, that after the statute limitations have run, that it is in effect a dismissal with prejudice. The problem that I have is that I think it's a matter for the legislature to have to deal with, as opposed to us dealing with it here. So can you address, maybe expand your argument a little bit on Wofford, why my concerns really should be put to rest by your argument?
well, because first, Waller did not require an act of the legislature. The statute said it requires a judgment. And when you look at the two statutes, the important aspect of the two is that both have the same objective. Both are designed to reduce and eliminate needless litigation. In the context of insurance policies, it's the objective is insurance companies don't contest legitimate claims. And if you do contest a legitimate claim and then give up your position, change your position, then you're going to owe fees. That creates a disincentive.
How can we relate that to this situation here?
It is I'm sorry.
Go ahead.
It's entirely parallel. What is the PFS statute designed to do? The PFS statute is designed to create a mechanism where if a party has a meritless claim, you can prevent them from dragging you through court, using the cost of litigation to extract a settlement, to get rid of meritless litigation by serving a PFS. And if they don't accept it, then they suffer the consequences of fees. It's exactly the same situation with insurance company. You can go ahead and deny that claim, but if you abandon your position later, an insurance company abandons its position by paying a claim. A litigant who files a meritless lawsuit, like happened here, abandons when they dismiss the case after a statute of limitations. They have abandoned the claim. The function of both statutes is identical. The objective of both statutes is identical. And the reasoning, if you look at the Waller reasoning, they said the statute must be construed to authorize the award of an attorney's fee under a policy where they bring suit after the loss is payable, even though there is technically no judgment. The statutory obligation for attorney's fees cannot be avoided simply by paying policy, but before judgment is actually entered, to do so would do violence to its purpose. That's what we're asking here. Don't do violence to the purpose of the PFS statute, which is to say there is a consequence for filing a lawsuit dragging somebody all the way up to the eve of trial and then saying, you know what, we abandon our position and walk away.
But can't we see the same with the dismissal rule? A plaintiff has the right, who brings a case, to dismiss their lawsuit all the way up until the verdict, right? I mean, they also have that entitlement to dismiss their lawsuit.
They have the entitlement to dismiss, but they don't have the entitlement to avoid the consequences. The same logic applies from Wahlert. The insurance company has the right to pay the claim, but that doesn't mean you can use that payment to dodge the judgment and dodge the attorney's fee claim. By doing that, you completely thwart the entire purpose of the fee statute.
Is there a difference here? Can you hear me? Okay. Is there a difference here where we have where we do not have the special relationship as in the case of Wofford?
No, because Wofford doesn't depend. The objective of, or the underpinning of Wofford is not the special relationship. It's the objective of having a fee statute to discourage meritless litigation. When you take a position in court, and what this recognizes is parties should not be subjected to having to pay for costly litigation against meritless claims. So the logic of both statutes is, if you bring a meritless claim, you do so under your peril. In the insurance industry, insurance context, if you take a position and give it up, you owe fees. In the civil arena, the entire purpose of the PFS statute is the legislature wanted to create a mechanism by which if you file a lawsuit and you get an offer and an opportunity to stop that needless litigation and you don't do it, there should be a consequence. And the PFS statute, there are plenty of loopholes in it, and because of joint liability and things like that, a lot of times it doesn't work the way it's intended. This is a situation where you can take the language of the statute, the words voluntary dismissal, and you can take the logic of Wahlert, combine those two things, and create a sensible rule. And this is not a new sort of position for the second DC to be in. Back in, I think it was 2008, in the carry-all transport case, there's a decision where the second DCA says, something, and they were using technicalities to nullify proposals for settlement. And they said, courts should not be nitpicking. And that really created, it enforced the legislative intent of the statute, the spirit of the statute, and achieved its objective within the confines of the language. And that's what Wahlert allows here. If you take the logic of Wahlert, the fact that both statutes are designed to reduce unnecessary litigation, then you can reach the objective consistent with Supreme Court jurisprudence and make the and achieve the objectives of that statute. And you don't have to take the leap that the Wahlert case did, because the Wahlert case took a statute, the Florida Supreme Court took a statute that required a judgment. This statute says voluntary or involuntary dismissal. So you can follow the letter of the law, you can follow the logic of Wahlert, you can achieve the objective of both fee statutes by making the decision that we requested today. I'll reserve the rest of my time for rebuttal.
Very good, sir. Thank you. Okay, Ms. Gregoire, do you want to proceed, ma'am? You've heard Mr. Samus. Why should we extend those line of cases to make it consistent with what Mr. Samus had just argued to the court?
No, Judge. First of all, I apologize for the artwork. I'm in my daughter's house in Colorado, and this is the only place I could set up. There is a.
I thought it was a great theme, actually.
It's a little embarrassing, but it is what it is. 1420, it almost creates a free pass for a first-time dismissal. The purpose of the rule is, and I disagree that it's based on meritless cases. There are a million reasons why a case might be dismissed the first time around. And if you combine 1420 with the statute 768-79, that requires a judgment of no liability. 1420 avoids that judgment of no liability by allowing a plaintiff or a petitioner to dismiss for a myriad of reasons. And in MX, the Supreme Court case from 1997, the court said we construe the language voluntary and involuntary dismissal in 768-79 to mean with prejudice. Here, the dismissal under 1420 is deemed without prejudice because there could be a second filing. Then that leads me to the statute of limitations. There are two cases, one from the 3rd DCA, one from the 4th DCA, in which the courts said MX, the Supreme Court case from 1997, requires an adjudication of no liability. The mere fact that the statute of limitations has expired does not equate to a judgment of no liability. If you go to the Waller case, and you know, if you look at
let's stop there for a second. Why not? I mean, Mr. Sammis's argument has an appeal because basically he says if you've had a dismissal and the law doesn't allow you to bring another lawsuit because the statute of limitations has expired, what is the real difference between that?
Because the real difference is written into the rule.
So you're going back to my argument that from a textualist standpoint, that's what it says, right? He made a very good argument about maybe it says more than you think it says. And I was kind of interested in the argument he made about, the way you could read those words. And because, candidly, one of the more difficult things we have today is that we are a more textualist judiciary than we were 5 or 10 years ago. We just are, for whatever reason we are. So Supreme Court cases 10 years ago that look at a statute and interpret it in a certain way, that's probably not how they're going to look at it today, is it? So we have to sort of take these things into consideration. And that's why I want this argument to be out there, because we have to recognize that the judiciary is more and more this way. We're more and more focused on what did the legislature say, less so than we are than what they might have meant, right? So help me with the language of this statute. How does it say what you want us to read it to say?
Because, it's not so much what I want as what MX said. This statute requires a judgment of no liability. The only way you can get to a judgment in this case is by going back to 1420 and undoing MX and saying, merely because the statute of limitations is expired, this equates to a judgment of no liability. But a judgment requires some action by a court. And where I was going with the Wallard case is if you take all of these cases and you lay them all out, all the cases that were cited in all 3 briefs, and you lay them all out, you can see a crystal clear line. Where Wallard applies is where an insurer has forced an insured to file suit and then paid the claim. So in essence, confessed that the insured was correct from the beginning, every single one of those cases. In this instance, the insurer filed suit and there is no judgment, and there shouldn't be a judgment. There's a case out of the 5th DCA, a 2015 case, so not old. It's Explorer Insurance Company versus, I think you say, Cayusma. There were 2 entities involved. One was a driver of a car, another was a passenger in a car. The insurer filed suit seeking a declaration that the insurer was not responsible for any payment to either the driver or the passenger. During the lawsuit, the insurer settled with the driver, and the court considered that a confession of judgment for which the driver was entitled to fees. The insurer did not settle with the passenger, and the Explorer court split the baby. The Explorer court said the driver has a confession of judgment as entitled to fees. The passenger had no recovery of any benefit. Every one of these cases on which Mr. Sammis relies there is a recovery of a benefit by the person entitled to fees. That recovery of benefit is the judgment that the legal fiction, the confession of judgment that results in the judgment that triggers 768-79. 1420 relieves the insurer of that path of confession to judgment because there has been no benefit to the insured. Was the insured hauled into this lawsuit? Yes. Did the insured have to expend legal fees? Yes. But that's exactly the circumstance that 1420 speaks to in allowing the dismissal that does not result in a judgment. And that's—
I understand you, Ms. McGuire. What you're saying, what you're explaining is that there has to be a judgment of no liability. And the case law, Mr. Samus indicated that our court, when we started writing about the confession of judgment, we're basically saying by virtue of the fact that insurance company has paid the amount, because by paying, we entered into this fiction, and we explained that by virtue of them paying the amount, they recognize that they were obligated to pay, that by itself is deemed to be a judgment for purpose of the statute to indicate that it was a judgment. And so, as I hear you, that's what it is. So I think what Mr. Samus wants us to do, and going back to Judge Morris's question, is about being textualist and looking at it. When you look at it, you have that requirement. And so the issue for us at this time, do we really want to extend those line in cases now to say that, and you're taking the position based on the legal fiction that we created, we don't get there. Am I hearing you correctly?
Exactly, Judge, because what's missing is the benefit. The confession of judgment theory, legal fiction, is based on the fact that the insurer, in Explorer, the insurer wanted a declaration that it didn't have to defend, and then it defended. That was the benefit to the insured that triggered 768-79 and resulted in the confession of judgment theory. You don't have that here. And Judge Morris, 1420 textually, 1420 could not exist, and MX could not exist if the result that Mr. Samus wants exists. It would completely undo MX, excuse me. And that's, I think, what the GAMI court, excuse me, the third DCA, and the Tucker court, the fourth DCA, recognized that the mere fact that the statute of limitations expires can't undo the rule that allows universal property and casualty to do what it did without suffering the consequences of 768-79. And that's really, at the end of the day, that is my argument. If you look at Waller, it was payment after suit was filed. Throughout the initial brief, Johnson versus Omega, Goff versus State Farm, Barretto, USAA, De Leon versus Great American, every one of them was an insurer that paid what the insured wanted paid after suit was filed, or settled the case after suit was filed. So in either instance, the courts have said that you have now confessed that the insured was right in the first place. In this case, Universal Property and Casualty didn't confess the insured was right in the first place. It dismissed the lawsuit for an unknown reason. There's no evidence at all that this was a meritless claim. And your honors know, I mean, you've all been on the bench a long time. You know that cases get dismissed for a myriad of reasons, not necessarily confessing judgment, not necessarily admitting blame. Sometimes there's an entire third reason for it. So I think if you look at those cases, if you divide the pile into here, there was a dismissal and no benefit. Here, there was a benefit. You'll see that the no benefit versus benefit is really the line on which the confession of judgment theory exists. And that, your honors, is really all I have to say. I've never needed 20 minutes, so I just give up the rest of my time.
Well, we appreciate you get to the point.
All right, let me make sure. Judge Morris, Judge Smith, any questions?
No.
All right. Mr. Samus, believe it or not, you have your full rebuttal time, 5 minutes, sir.
Oh,
okay.
Terrific. Well, I'd like to just start by saying, of course, the dismissal is the benefit. This dismissal of the lawsuit is exactly what my clients wanted The lawsuit is what the plaintiffs wanted. They gave up their position. That is exactly the same benefit as an insurance company that pays a claim. The plaintiffs sued, they wanted money, the insurance company gave money. My client is the defendant. My client wants the suit to be dismissed. To win the lawsuit, they have done that because they not only dismissed it, they dismissed it after the statute of limitations. Now, let's talk about textualism, because that all flows in the direction of my client's position. Number one, Rule 1.420, all that does is allows you to refile a lawsuit. You can dismiss it once and refile. The entire effect of 1.420 goes out the window, and its entire effect is nullified when the statute of limitation is run. Rule 1.420 says nothing about attorney's fees. It has no reference to attorney's fees statutes. All it says is you can dismiss once and bring a lawsuit later as long as you're in the statute of limitations. It doesn't eliminate any consequences of that dismissal. Number two, the language of the PFS statute again says, after entry of a judgment or after voluntary or involuntary dismissal, not a qualifier. And as Judge Morris pointed out, when you say voluntary dismissal, the presumption in the law is that it's without prejudice. So clearly,
I got it backwards though, and you were right.
Yeah. Now, and you know what? It's an important, and you know something, I'm glad you brought it up, Judge, because I didn't think about it, but a textualist like the current Supreme Court of the state of Florida will say, well, I don't see the words with prejudice in this statute. So therefore, there's nothing in this statute that requires a voluntary dismissal with prejudice. It just says voluntary dismissal. So a strict textualist agrees with us. So there is every reason that exists in Florida law for interpreting this statute.
Well, I guess, Mr. Samus, the issue I have from a textualist standpoint, the legislature knows how to write what they want to say in statutes. And if they really wanted us to treat a dismissal after the statute of limitations is run, they would have included in the litany that they said where the statute applies. And they just didn't say that.
They did say that. When they said voluntary dismissal, they said that. They didn't qualify it.
Well, they didn't say what this and the statute of limitations is run.
I mean,
so it's a functional equivalent of a judgment or words like that. And they didn't
the
serve that up to us, which is what, this is what people argue today, how we should be guided. If they didn't say it, we should not supply the words.
Well, I'm not asking you to supply the words, Your Honor. The words voluntary dismissal are there. The legislature is not going to write a statute that says voluntary dismissal for reasons. That is an unwieldy statute. If you read the words of the statute, they are completely consistent with our position. And here's the other rule that exists today, as it has existed for the last 180 years, is that the legislative intent is the pole star by which you interpret statutes. The legislative intent here is if you get a PFS and you give up your position, then by the logic of Waller, by the language of the statute, you suffer that consequence. So you have the language of the statute, you have legislative intent, you have MX, which is confined only to pre-statute of limitation, you have Waller, which you can cut and paste that opinion and use it in this case. So let the Supreme, conflict with the third and fourth, and let the Florida Supreme Court decide whether these words mean what they say. So we ask that the court reverse.
Mr. Samus, it's amazing. Based on my timer, you had 40 seconds left on your argument, so well timed.
Well, you know what? I'll use that to straighten my tie, Your Honor, because it's been driving me crazy through the whole argument that it was correct.
You both did a great job. Your arguments were excellent.
It truly is. It's a very interesting issue, and really, I echo what Judge Moore said. Well argued on both sides. Thank you.
Thank you, judges.
Good to see everybody.
Well.
Yes.
We'll leave now. Bye.
Bye-bye.
Thank you. And I know there'll be a brief pause